So at their best, a constitution, the laws, and a court system are instruments we shape and wield to move closer to justice. I've learned over the many years since I spoke with those law students right here in this building that this lesson is not one for budding lawyers alone. All of us in the legal profession, young and old, wet behind the ears or long in the tooth, must be lifelong learners and lifelong seekers. And that kind of education requires us to ask ourselves regularly, is law just? All of us, including me. In fact, old lawyers are among the first to neglect basic principles such as the gap that separates the rule of law and a sense of justice. When I was asked to serve as Governor General of Canada beginning in 2010, I discovered I had much to relearn. Despite my background as a law student, a professor and dean, I had to revisit the legal principles and conventions, not quite law, but with the force of law, of our Constitution, especially as they relate to the authority and function of the Crown in Canada. My re-education enabled me to develop an even deeper admiration and sensitivity for how precious the rule of law is in our country, how thin and vulnerable its veneer can be, and how vital it is in moving closer to justice. In fact, so passionate have I become about this that I write books about this kind of thing. Book Trust, which came out just a few months ago, really was motivated by my very real concern about the erosion of trust in our public institutions and a whole host of other trust relationships. An earlier book was called The Idea of Canada, Letters to a Nation, did 3 or 4 years ago, again based on this concern about civility and civilization. And then 2 books we wrote on innovation, attempting to enhance the culture of innovation in the country, which I think too is important in building trust. But what I found in my re-education, this marvelous opportunity to come to understand the Constitution and conventions and the rule of law in Canada from a little different perspective, this perspective of the Governor General, it revealed for me anew that truly the study and practice of law is a hollow pursuit if we don't use it to strive toward justice. That's the foundation. That's the basic principle. When I consider this need, Hugh MacLennan's analogy, comparing gardens to civilizations, comes to mind. His words from his last novel, Voices in Time, which I thought was his greatest novel of all, are worth examining or quoting in full. He wrote at that time, in the relatively rare periods in the past that we call civilized, people understood that a civilization is like a garden cultivated in a jungle. As flowers and vegetables grow from cultivated seeds, so do civilizations grow from carefully studied, diligently examined ideas and perceptions. In nature, if there are no gardeners, the weeds that need no cultivation take over the garden and destroy it. Well, to alter Hugh MacLennan's analogy slightly, justice is a flowering seed that must be cultivated, and we, the lawyers, must be its diligent gardeners. So, how do we go about being diligent gardeners in the cultivation of justice? And taking my cue from my brother, 3 points. We champion our profession's social contract, we strengthen the public's trust in us and our profession, and we serve the public regularly and seek the good always. Seek the good always. So, let's start by championing our profession's social contract. In Ontario, new members of the bar swear an oath, and it goes this way. I accept the honor and privilege, duty and responsibility of practicing law as a barrister and solicitor in the province of Ontario. I shall protect and defend the rights and interests of such persons as may employ me. It continues, I shall neglect no one's interest. I shall not pervert the law to favor or prejudice anyone. And then, of overwhelming importance, it finishes, I shall seek to improve the administration of justice. One of the best modern reformulations of professionalism in the law is the American Bar Association's Model Rules of Professional Conduct, which states, a lawyer as a member of the legal profession is a representative of clients, an officer of the legal system, and a public citizen having special responsibility for the quality of justice. The ABA's professional committee is even sharper on this point. A professional lawyer is an expert in law pursuing a learned art in service to clients and in the spirit of public service, and engaging in these pursuits as part of a common calling to promote justice and public good. So these obligations to our clients, to the public, to justice, constitute the social contract that we have with our fellow citizens and our country. We must do our very best to live up to our contract each day and not merely recite its conditions on one day. All professions, not simply the law. Doug Blocking, the wonderful Dean of Medicine when I was here. I was just saying to Doug, the first day I was here, I was at a meeting of deans, and I was really a pretty young rookie. And Doug introduced himself, said, we're sister faculties, law and medicine. We share the same convocation. Where are you staying? And I said, well, I'm actually staying in a place in residence because the family are at a cottage for another 2 weeks. He says, so you're on your own? I said, well, yes. He says, well, come for dinner tonight. And I said, well, don't you have to check with your wife? He said, no. So my first night here was dinner with Doug and his wife, and that was just the beginning of the wonderful welcome that I received from the great people in this Western family, beginning with the Dean of Medicine. Thank you, Doug, for that. All professions have their own social contracts, and each is made up of, again, three principles. The first is a profession is characterized by specialized knowledge that is taught formally and obtained by experience and under supervision. Second, the state gives a profession the right to have a monopoly, to control entry and exit standards and competence, and to some degree, fees. Third, the profession has a responsibility to society, the social contract, the public trust that goes beyond the needs of specific clients. So that's the deal we've made as professionals. If we fail to meet our obligations under that social contract, then citizens, through their elected representatives, will change it and redefine professionalism for us. Regulation and change will be forced on us, quite possibly in forms that diminish or remove some of our self-regulatory privileges. And that's not an abstract discussion. For example, the 2008 financial collapse is a powerful illustration of our profession's failure to meet our obligations under a social contract. Now, this may seem a bit remote to you, but just bear with me. That crisis shook the principles and institutions of the global economy, in particular trust, to such an extent that we're still feeling and dealing with its aftershocks, socially and politically, as well as economically. To some extent, the populism that we have seen rise up not only in the US but in other countries is a manifestation of some of the consequences of that 2008 collapse. It reflected poorly not only on financial professionals, but also lawyers. How many in our profession papered the deals that involved fraudulent statements of assets, liabilities, income, valuation, and risk? On the flip side, how many lawyers sounded the alarm about conflict of interest in the web of financial transactions and instruments? Even before that, how many lawyers were silent in the face of a pattern of deregulation that left the US economy naked to excessive leverage? And what's especially surprising is that we had a precursor 7 years earlier. The dot-com crash of 2001 involving Enron, WorldCom, and others brought in the Sarbanes-Oxley framework of rules to regulate businesses that operate in the US. This rigid framework replaced principles that corporate lawyers could interpret using their best judgment and highest ethic. It established a system of detailed rules and regulations rather than principles which could be followed to provide a more general guidance. It ended up being very costly to follow and of questionable effectiveness at the micro level, and at the macro level it encouraged an even greater system of excess to fall into place. In the wake of these crises, many in our profession stand guilty of focusing on doing the thing right operationally rather than doing the right thing ethically. Which brings me to the next way, point 2, in which we lawyers must be diligent gardeners. We strengthen trust in our country. Trust, writ large, is fundamental to Canadian democracy. Our democracy depends on a rule of law that strives constantly towards justice. Our rule of law depends on trust among citizens and between citizens and the professionals and institutions that serve and represent them. Trust in these relationships means knowing certain basic truths exist. It doesn't mean those of us in democracies must agree upon absolutely everything. It does mean we must acknowledge the real state of the world. There is such a thing as truth. There are such things as facts. Objective journalism is possible. History can be learned and learned from. If one does not consider anything to be true, if one believes facts are fungible commodities, if one thinks journalism is a lie and history a con, then the rule of law cannot work. And if the rule of law cannot work, then not only can we not use it to move closer to justice, our democracy and its institutions are doomed. One pivotal action we lawyers can take to strengthen trust is to insist on doing the right thing, and not merely the thing right. Put more formally, we must adhere to the moral imperative ahead of the operational. Charles Dickens understood this principle well. At the center of his novel Bleak House is Jarndyce and Jarndyce. This was another of the books or movies, along with To Kill a Mockingbird and Judgment at Nuremberg, that I would regularly urge my students to read or to see. The legal case, Jarndyce and Jarndyce, deals with a large inheritance, the disposition of which has droned on for generations. The matter is finally resolved by novel's end, but not before inflicting a cruel fate on each of the main characters. As for the inheritance, it has been rendered worthless, having been consumed by lawyers' fees. This satire of English legal proceedings is grounded in similar such cases in which the system and its professionals operated according to accepted rules and practices. Things were done right, but evidence of the right thing being done was nowhere in sight. Dickens' treatment of this case reminds me of a cruel joke in the medical profession. The operation was successful, but the patient died. Voltaire once remarked, "I have been ruined twice in my life, once when I lost a lawsuit and once when I won." Our placing of the operational imperative ahead of the moral isn't the stuff of literature only. A contemporary instance is the administration of our own courts. The Ontario court system has been slowed by an inordinate number of unproductive appearances and some of the longest court delays in the country. In a study of court proceedings times across Canada, University of Toronto criminologist Anthony Dube found that in cases where no bench warrants were issued, Ontario had 3 times as many cases lasting more than 8 months than did Alberta. That is, the delays in coming to trial. And Alberta doesn't exactly stand at the top of the list of expeditious standards of court administration. Ontario has tried to reverse this trend through the Justice on Target program and methods such as streamlined disclosure, meaningful first appearances, and dedicated prosecution. But years later, the pace is still woefully slow. As a matter of fact, in the list of OECD countries, we stand in the bottom third with respect to justice denied or justice being slow. Wide discrepancies exist all across Canada, both in our criminal and our civil justice system. The most recent World Justice Institute ranked Canada 20th out of the nations surveyed on the access to justice, behind 4 of our G7 partners. Anthony Dube suggests that reducing these delays requires to look hard at what he calls court culture, that is, shared expectations about how things should work among judges, the accused, defense counsels, crown attorneys, and legal aid. And recently, many of you will know the Supreme Court of Canada ruled that criminal cases which were delayed from trial for more than 4 years would be thrown out. And we had dozens and dozens and dozens of cases, including charges of murder, thrown out simply because we were not getting on with providing a reasonably speedy trial for the accused. And so we must engage our most innovative thinking to regain our focus on serving the public and ensuring that that administration is just. We can achieve this goal in so many different ways. One, I would suggest, is avoid the tort law morass of U.S. law. 2, simplify legal procedures and render them more cost-effective. 3, examine the scope of practice to unbundle activities that do not require legal professionals, or legal professionals as the first instance. And move the industry standard of pro bono work, including cases, teaching, and law reform from the current rate of less than 3% to 10%. And build these honorable hours rigorously into the firm's revenue structure. And if we wish to avoid having change forced upon us, we must embrace such new ideas and innovations. Let me illustrate this point with an example from the medical profession. All Canadians would be wise to learn about the life of Dr. Thomas Rawdon. He studied medicine at McGill University in the 1850s, 1860s, went to Scotland, as all the bright McGill medical graduates did, up to the University of Edinburgh, which actually founded McGill in 1827 with four surgeons who came from the University of Edinburgh and were practicing in Montreal. There he graduated in surgery and studied under Joseph Lister, who was a pioneer in the use of carbolic acid to disinfect his operating rooms. In fact, Lister was so convinced of the beneficial consequences of carbolic acid that his operating rooms were so bathed in it that he actually lost the use of his hands from carbolic acid poisoning. But young Roddick returned to McGill, and he opened a third operating room right alongside the operating room of the two senior surgeons who had been his teachers, his professors. And he bathed his operating room in carbolic acid to stop cross-infection from a patient who had just been operated on to the next patient along that the surgeon was treating. And after about a year of this practice, with the other two senior surgeons saying, not going to mess up my operating room with carbolic acid, Sir William Osler was then a relatively young physician at McGill, later went on to Hopkins, later went on to Oxford, was probably the most influential physician of his time in the English-speaking world. His book, The Principles and Practice of Medicine, went through 42 editions over 100 years, so that's Osler's remarkable contribution to medicine. Left his History of Medicine library to McGill. Michael Bliss, that wonderful author, wrote a biography of Sir William Osler. Was quite marvelous. In fact, Osler was a man of some reputation at this time. And when he discovered that Roddick's operating room had a mortality rate of less than 2% from cross-infection and used carbolic acid, and the two senior surgeons disdained mess up their operating rooms, had a mortality rate of above 20%, he said to the dean, if you do not insist that those two surgeons change their operating procedures, introduce carbolic acid tomorrow, the Montreal Gazette will carry the following story the next day. And they changed their practices. So you learn some things about this kind of story. As lawyers, we learn several lessons from an anecdote like this that we can apply to do the right thing and to strengthen public trust in our profession. We must use best practices from other jurisdictions and be particularly open to the ideas and energy of younger members of our profession. Our most respected members of our profession, the Oslers of the world, must be prepared to intervene to secure the public good. We must create a culture of constant renewal and continuous improvement in practice and evidence-based learning. We must ask ourselves what the public expect and what members of the public would say if they really knew what was going on in our profession. And finally, we must serve the public good regularly and seek the good always. So that's my third admonition to you as legal professionals. Seek the good. I found throughout my experience that lawyers can best seek the good by serving the public. We as a profession have traditionally done well, for example, in our appointments to the bench. For the most part, we have an extremely high level of competence and trust. I recognize one of the great justices in Ontario, Lynn, who was a magnificent, brilliant student during our time together here, Steve, and shortly after. We have this competence. We have this high level of professionalism on the bench because our most accomplished colleagues are prepared to reduce their level of compensation to join the public service. We must build on this precious tradition of competence and integrity on the bench. It's a fundamental responsibility requiring constant vigilance that only the most worthy amongst us are elevated to the courts. Lawyers are particularly well prepared for public service generally, yet we're substantially underrepresented in the public service across the country. So we should do more to ensure that all other areas of Canada's public service are able to draw from our profession. And we must ensure that the quality of the work, the opportunities, the function of all professional leaders are rewarded and appropriately respected in these areas. And part of the trick is to ensure that prospective law students and lawyers are fully aware of opportunities in the public service and that we encourage movement back and forth between the practice of law and service to the public. One of the wonderful lessons I learned in 7 years as GG was the quality of the public service of Canada And it's not very well known, but there's a study out of Singapore that evaluates the quality of public services across the country in OECD countries. And Canada has led all of those OECD countries for the last 3 years in the professional quality of our public service. Something that I guess we take for granted, and we tend to be quicker with criticisms of great challenges like the Phoenix pay system and now some of the many good things that are done day by day. Well, I've given you a lot to think about, so let me sum up what I'd like you to take away. First of all, the rule of law and a sense of justice aren't the same thing. Secondly, at their best, a constitution, laws, and a court system are instruments we shape and wield to move closer to justice. To borrow novelist Hugh MacLennan's analogy, justice is a seed that we lawyers must cultivate so that it grows and blooms and flourishes. And being diligent gardeners in the cultivation of justice requires us to champion our profession's social contract, meeting and rising above our obligations under it. Being diligent gardeners in the cultivation of justice also requires us to be increasingly worthy of trust as lawyers and as a profession. We strengthen the public's trust in ourselves and our profession by doing the right thing ethically always, and not merely the right thing operationally. Being diligent gardeners in the cultivation of justice requires us to serve the public and in doing so seek the good in ourselves, our fellow citizens, and our country. The search for absolute justice is an impossible pursuit. We will never reach it. Yet, we must never stop behaving as if we could. We must never stop striving toward justice, building trust in our profession, improving the rule of law, and seeking the good as we go. And let me finish with a little couplet from one of my favorite writers, George Bernard Shaw, once wrote, "Some people see things as they are and wonder why. We dream of things that ought to be and ask why not." Merci.